Welcome to Temporary Protected Status for Haitians in Removal Proceedings, sponsored by the ABA Commission on Immigration. To receive CLE credit, you must attend the entire program. Partial credit is not available. Please click on all participation verification alerts to confirm your attendance. After the program ends, a link to complete the certification process will appear. Please complete the evaluation and the CLE affidavit, providing your bar information as requested, and submit. Once your attendance is verified, your certificate will be emailed to you. Moderating the program today is Stephanie Baez. Stephanie is pro bono counsel for the ABA Council on Immigration and works out of the Immigration Justice Project office in San Diego. Stephanie, you may proceed with the program. Thank you.
Hello, everyone, and thank you for joining us today. As mentioned, I'm Stephanie Baez, pro bono counsel for the ABA Commission on Immigration, and I'd like to briefly introduce today's speaker. Joining me on today's program is Cassandra Suprin. Cassandra is currently the Family Defense Program Director at Americans for Immigrant Justice, AI Justice. She represents clients before Immigration Court, the Board of Immigration Appeals, USCIS, and Immigration and Customs Enforcement. Please feel free to read Cassandra's extensive bio online, which is in your program materials. But for now, welcome, Cassandra. Thank you so much for joining us today.
Thank you for having me, Stephanie.
And as a quick roadmap for everyone, we're going to start by providing an overview of TPS and specifically the Haitian extension and redesignation periods that have been recently announced. Then move into strategic considerations for TPS eligible Haitians in removal proceedings, then a discussion of firm resettlement issues, some special considerations with redesignation, and finally a Q&A period. If you have questions, you can put them in the Q&A box, and we will be reviewing them throughout the presentation, but we'll make sure we take time at the end to answer the questions that have been entered into the question and answer box. So to start, we will do just a quick overview of what is TPS, and I'll turn it over to Cassandra, but first I want to remind everyone that this program really focuses on TPS for people in removal proceedings. And if you need a background refresher on just a TPS 101 course, we do have already recorded webinars that cover those topics. The links are in the program materials that were sent out to you as part of today's webinar. On this slide, those are live links in the program materials if you just want to watch a basic TPS 101 and TPS 201 for Haitians. But with that said, Cassandra, maybe you could just provide us with a brief introduction overview of TPS.
Thank you, Stephanie. TPS is a temporary status offered to certain countries by the US government where said country has suffered some sort of civil strife, natural disaster, so on and so forth. Basically, for you to be eligible for TPS, a country has to be designated by DHS. The person has to be a national of said country or lastly habitually resided there. The person has to be in the United States at the time of the designation date, has to be continuously residing at the time of the designation date, and has not committed 1 felony, 2 misdemeanors. The person cannot be firmly resettled in a third country, and there's some sort of other ineligibility questions, which is mostly the persecutor bar, other national security reasons. So that's basically what TPS is.
Great. And then moving into TPS for Haiti specifically, how many times has TPS been designated for Haiti?
TPS has been designated for Haiti 4 times. The first time was on January 21st, 2010. That's when after the earthquake in Haiti. It was subsequently redesignated in 2011. That's the second TPS. The third TPS happened on August 3rd, 2021, after the assassination of the Haitian president Jovenel Moïse, and the last one happened on November 6, 2022. For the purposes of this webinar, we're going to refer them as TPS year, TPS, or first TPS, second TPS, third or fourth TPS, because there's so many nuances between them, and I want us to just keep us aware of which TPS we're referring to.
Got it. And And as we're talking about them and this new, the fourth TPS, the 2022 TPS, um, that has involved a re-registration and redesignation period. What does that mean? Can you describe some of the basic terminology and the difference between the initial TPS period and then what re-registration and redesignation means?
Okay. When a country is designated, there's a registration period. The initial registration period is the time frame that a TPS eligible applicant needs to apply in order to be eligible. So for you to be eligible for TPS, they will give you a time frame for you to apply. So during a designation period, there's a registration period. Now, once they grant TPS for said country, if they decide to extend TPS for said country, there will be a re-registration period. Now, the re-registration period are people who already were granted TPS during the initial designation, and now they re-register in order to maintain their TPS status. And now, sometimes, as time has passed, because of the situation of the same country, they have redesignated TPS. That means they made a new designation for TPS, and there's a new date. And during that date that they redesignated, they will give a registration period, and the person has to re-register. Let me give you an example. For TPS for Haiti, the 2021, which is the third TPS, was announced on August 3rd, 2021. The person had to apply by February 3rd, 2023. But during that extension, so the US government decided to extend TPS for the 2021 TPS and also designate a new TPS for 2022. So that's where the confusion lies. So the ones who apply in 2021, usually when they're giving a re-registration period, the US government as a policy gives 60 days. So for the people who apply in 2021, have 60 days to reapply in order to maintain their TPS status. So those people should apply from January 26, 2023 until March 27, 2023. Now the newly designation, the redesignation, which is the fourth TPS, they have from January 26, 2023 until August 3rd, 2024. So for the fourth designation, they have initial registration date of the whole entire TPS period for them to apply.
Got it. So right now there are people who already had TPS who have a short window to reapply or re-register that TPS. And then there's a whole other group of people who didn't previously have TPS who are now newly eligible to apply under the redesignation period.
That's correct.
Okay. Got it. And so that's why we now have a lot of people who are potentially in removal proceedings who are potentially now newly eligible for TPS, whereas they weren't eligible for any of the prior registration periods.
That's correct. And that's where, as a practitioner, what do you do in those cases where a new form of relief is the person's eligible for? What do you do for said person when they're in removal proceedings?
Great. So that brings us into our main topic for today, which are the strategic considerations for TPS eligible Haitians who are in removal proceedings. And I guess to kick us off on this discussion, just a background question so that make sure everyone in the audience is on the same page. What do we mean when we're talking about removal proceedings?
Removal proceeding is when DHS has issued a notice to appear to a foreign national because either they violate their terms of their visa, they have committed some sort of crime, or they didn't have status when they entered. That's when they put you in front of an immigration judge for them to assess whether you actually are removable under the allegations and if you're going to present some sort of relief in order to get status in the United States.
Okay. And just by way of comparison or contrasting, what's the process for affirmative immigration before USCIS?
So difference between so basically when you're in front of a judge, that's defensive immigration because you're trying to defend your removal. Affirmative is when you apply and you're not in removal proceedings. So for instance, if you apply for asylum and you were not caught at the border, you had some sort of status and you apply for asylum, you will file it at the asylum office. If you are applying for a green card and you're not in front of a judge, you will apply most likely before the USCIS. So that's affirmative. You're affirmatively taking steps to apply. Defensive immigration is when you're in front of a judge.
Okay. And someone who's in removal proceedings, if they're at any stage in removal proceedings, are they eligible to apply for TPS before USCIS?
Absolutely, they are eligible. And just to note that USCIS has initial jurisdiction on TPS. So if the person is in removal proceedings, you will not file the initial TPS with the judge. You will file it with USCIS. And if USCIS approve, you have other recourses before the judge. If the USCIS denies it, you could review it de novo before an immigration judge.
Great. Okay. And then one main consideration to consider when deciding whether to apply for TPS is what are the benefits? So if you have a client who is currently seeking asylum in immigration court, would they want to also apply for TPS? And maybe to help with that discussion is to provide context of what are the differences, some of the key differences between TPS and asylum, and why would someone who's seeking asylum potentially also want to seek TPS?
Okay, so let's talk about the pros and cons for asylum and TPS. TPS, as I mentioned before, it's a temporary status. It's granted because the government feels like there's some civil strife or natural disaster where said foreign national cannot return back in their home country. It's designated for a period of time up to 18 months and is renewable at the government's discretion. So the good thing about TPS, it could happen at any time given what's going on in home country, and it's good for 18 months and it could be renewable. Asylum by itself is when you fear of returning back in your home country because you were persecuted or will be persecuted on the account of race, race, nationality, religion, political opinion, or you are part of a particular social group. And wherever you go in your country, you will suffer said persecution. So basically, those are the requirements. But the good thing about asylum is it's a long-term relief. If the judge or you go, well, we're talking about the immigration court context, if the judge grants it, the moment that you're granted asylum, you become an asylee and you have an indefinite status. You're eligible to work, and after a year, you could apply for a green card. The good thing about asylum is if you're granted, it confers benefit to your derivatives, i.e., if you have family members, your wife or children who are under 21, who at the time you apply for asylum were granted, they are also, if they were added in the asylum, they become asylees. If they were not part of your asylum application, you could still bring them in under I-730. So the asylum, the good thing, it confers some sort of permanent benefit. The downfall for TPS is it's temporary. There's no derivative. Every person in your family has to independently be eligible for TPS. So that means if you have somebody in home country and you're granted TPS, you cannot bring them as a derivative, contrary to asylum. So at this point, you as a practitioner, you are aware the benefit of being granted asylum and the benefit of TPS. Sometimes it helps you in the immigration context before a judge. Please note that some asylum claims are not as strong, and we were fully aware, and that would be probably the last resort for the person to have a hearing before an immigration judge. So if the person is TPS eligible, you could still apply for TPS for that person and still pursue your asylum claim. One does not affect the other. So at the end of the day, even though the person is a TPS recipient, you could still pursue the asylum, especially if it's a strong asylum case. If it's not a strong asylum case, that could be a way that you remove the person from immigration proceedings, right? Because now, as we're going to talk about PD, terminating proceedings, and other situations, the person may have a fairly relative good claim, but there's some documents you are waiting for in order to really bolster their asylum application. Having TPS could be a way to say, Judge, let's temporarily AC the case because, we want to go forward with our TPS claim, and therefore we would put the asylum claim aside. And when you have the documents that are necessary to make the asylum claims strong, you could try to recalendar. We will talk about this shortly. But the good thing about asylum is be mindful. You cannot forego a strong case for something that's temporary. So be mindful, it's on a case by case basis. Some of them did not have the option, they're already in removal proceedings. They really didn't have an asylum claim. That could be a way of removing them with the TPS, given what we're going to discuss. Others, just because you have TPS, still file for TPS and you could still pursue the asylum application simultaneously.
Got it. Okay, that's helpful. So we've talked about the fact that it is possible for someone who's seeking asylum to then also file for TPS simultaneously and to pursue the two different forms of relief at the same time. Um, and I guess the question then would be if, and you just touched on this, so I think we might have already answered the questions on this slide. So I think I'm going to move forward to the next one because you were talking about prosecutorial discretion and the possibility of administratively closing or dismissing a case in removal proceedings in order to pursue the TPS claim. I'd love to hear more about that. And maybe first, just a description for the audience of what is prosecutorial discretion? What does it mean when you're talking about that?
Prosecutorial discretion is basically what it means. The government attorney, DHS, has decided to exercise discretion to not prosecute a case. So basically, they could decide to dismiss the case. That means they're not prosecuting, or there's an assessment on the NTA, and they decide, judge, they're going to terminate, and they're not going to fight the case. So dismissal, termination, that means your case is no longer in front of an immigration judge. You no longer are in removal proceedings. Administrative closure, it's different. It's a decision where the government attorney has decided join, or you could request you could request administrative closure, and DHS may join and the court may agree. If your case is administratively closed, you are still in removal proceedings. The only difference is you're not on the active docket. Is that they place your case aside for the foreseeable future. So at this particular point in time, although you're still in removal proceedings, you still are in court proceedings, you just don't have a hearing date. And when you have administrative closure, at any point in time, you as a practitioner or the government attorney may elect to reopen, actually put your case on an active docket again, which would be motion to recalendar removal proceedings. So basically, they're going to put you back on the calendar on an active case. So the good thing about dismissal, you're no longer in removal proceedings. Administrative closure, the good thing about it, you still are in removal proceedings, but you're not on an active docket. Now, some people would say, well, why would you want to do administrative closure in some cases and not dismiss? Be mindful is the good thing about administrative closure is sometimes, depending on the relief pending before the judge, it's great to AC the case, which we call administrative closure, AC the case, because the person could still be eligible for a work permit while the case is being AC'd. So be mindful of that. So you have to be very strategic about the case that's pending before the judge. Other times dismissal is the best possible scenario because sometimes the person doesn't really have a relief, but unfortunately they were caught at the border, put in removal proceedings. Now they're eligible for TPS, and now the government attorney may say, you know what, we decide not to prosecute this case. Let's dismiss this case because this person is TPS eligible. That could be a way out of being in immigration court. But other cases, it may really be beneficial for the person to AC the case. Now, we have cases where you would like to AC to preserve their work permit or because you want to pursue the asylum. I have seen judges who do not want to administratively close the case. They want to agree to dismiss the case. If that's the case and you have a strong asylum claim and the judge says, listen, I could give you a hearing for 2027 or take the dismissal, that could be a case you take dismissal but still apply for asylum at the affirmative step, explaining there's no 1 year issue. because you did file your asylum within 1 year and provide the document saying that you filed it in court, but the court decided to dismiss, and therefore the asylum office has jurisdiction. So there's so many little caveats. You have to look on a case-by-case basis on see what's the best course of action for your client.
Okay, so if just as an example, if there is, and you were touching on this, if there was a Haitian family that came across that is now newly eligible for TPS, they're in removal proceedings, and they have applied for asylum within the 1 year filing deadline, and according to the employment authorization clock, they only are about like 10 days into their employment authorization period. In a situation like that, would you recommend that they dismiss and terminate, or would you recommend that they administratively close when they're not very far along in their employment authorization clock?
Well, it really depends on the case. If it's a strong case, you talk to the client because it really depends on the judge's docket as well. There's so many factors. But if the person doesn't have a good asylum case and the clock, because the clock is not going to run when you administratively close, right, Stephanie? It stops at the time frame when it's AC'd, correct? So you're not accumulating any more days. You're not going to get to the 150 to apply, then 180 to get it granted. So that could be a case that you may decide to dismiss the case, pursue the asylum affirmatively, and just get the person out of court. Because think about it, court is the last stop. But if you go before the asylum office, it doesn't get approved, they'll send you back to court. So you get two bites of the apple. So you have to really be mindful. If you have a great judge, right? A judge who has consideration for this particular type of asylum case, that could be a case that you decide, you know what, given that they have a fair shot and it's a great judge, probably take your shot there. So it really depends. There's so many factors to consider. It's not a black and white. But if you're thinking about the EAD purposes, ACing, you're not adding any more days on the clock for a work permit.
Got it. And the slide just went backwards one, which is funny. I don't think I did that on purpose, but I think it's a good question. A follow-up question is, what if you decide, if you have a client who has a really strong asylum case, and what if they say, I don't want to leave removal proceedings. I think I'm going to win my asylum case in removal proceedings. I'd like to try that. But then if I lose, then could I still apply for TPS? And what are some of the considerations there in terms of maybe late filing TPS or other things to consider if there's a client who says, no, I really want to keep going. I'm close to my hearing and I want to keep going in removal proceedings. What are some things to consider there?
Well, first thing to consider is when is the registration period will end, right? If the hearing is happening before the registration period, that's something you could, talk to the client if that's what they want. At the end of the day, it's the client's decision. It's not yours. You are here to give them sound advice, sound information, and they are going to make an informed consent based on the information that you give them. So if the person wants to pursue their asylum, that's on them. The one thing you could look into, you're going to look at when is the deadline to file for TPS. Is the hearing going to happen before the registration period or after? That's one thing you would consider. The second thing is there's something called late initial registration, where you could still apply for asylum you could still apply for TPS within 60 days after the judge denies your case, and you still could explore that possibility. But be mindful that there's certain things that we're going to talk in the future about down certain slide that you have to be very mindful, because just because you could file within 60 days after they deny your asylum, if the judge filing it's a frivolous asylum, makes a finding of frivolous asylum, you're knocked out of TPS. If the judge finds there's a firm resettlement issue, USCIS may use that argument to say that you firmly resettle. And please be mindful, just because the judge found a firm resettlement, that means technically DHS brought the firm resettlement claim. You had the burden to overcome the firm resettlement. You did not overcome it, and the judge made the findings. So USCIS could use that as a tool to say, well, there's a firm resettlement issue and we'll deny your asylum. So there's so many things to consider when pursuing an asylum claim. Again, like I say, you as a provider, you have to give the applicant all the information necessary, and it's up to them to make a decision. And from there, as long as you give them the information, if they want to pursue it, they want to pursue it.
Okay, and moving forward, if the client, you touched on this already, if the client does still want to pursue asylum, they want to seek TPS and asylum at the same time. So they're in removal proceedings, but the case has been with prosecutorial discretion. Let's say it's been dismissed, and then they decide that they want to seek affirmative asylum before USCIS. Um, what do they need to do? Just talking about the logistics of that, do they need to, is the application automatically transferred over to USCIS, or what do you need to do for your client to make sure the case is now transferred to an affirmative posture?
So what you do, it's not transferred automatically to the asylum office. You have to affirmatively file with the asylum office. What you need to do when they say, have you filed your asylum application after the 1 year, I personally put no, and I give an explanation. I tell about the date of entry of my client, when it was filed, when it was received by the court, and say that the reason why we're filing before USCIS is because the judge has decided to dismiss or terminate proceedings, and therefore we want to pursue asylum. And right now, because they're no longer in removal proceedings, USCIS has jurisdiction. And I provide proof that it was filed within the 1 year. For instance, let's just say the person has an NTA stated that they entered on January 1st, 2022, let's just say, and the judge accepted the asylum application on June 2022, which is 6 months. I would provide that stamp from the judge. If the person was fingerprinted for the I-589, I provide that as well. And in that box, I checked everything and just clearly say that USCIS has jurisdiction.
Got it. Okay. And in practice, have you been hearing or seeing that people have been having trouble? Have applications been getting denied because of that 1 year filing deadline, or has it been okay, or is it too soon to tell?
Well, I've only done a couple. I haven't had an issue. They're just pending. They're in abeyance like the other cases. I think the biggest concern trend I'm seeing is if the person has an NTA and not put in removal proceedings, and now they're filing affirmatively. I've seen letters that the asylum office saying that they don't have jurisdiction because they're in removal proceedings, although they're not actually before the judge in the system.
Ah, okay. So meaning they've received the NTA, but the NTA hasn't yet been filed with the immigration court.
Correct. Yeah,
Got
I've
it.
seen USCIS saying they're not going to take jurisdiction, but if you have a termination or dismissal, they're taking jurisdiction from my understanding.
Okay, great. And I know that I've seen chatter on listservs. Every jurisdiction does it a little bit differently in terms of this process. And so I know just anecdotally that I've seen some people say that when they are seeking TPS and they've asked for prosecutorial discretion in their jurisdiction, they've asked the judge for they're getting creative and asking for something like a transfer. Can you transfer the case to USCIS so that there's no issue with the disruption of the 1 year filing deadline? I've heard some people say that their judges have done that and have issued a written order saying, I transfer this case to USCIS. I've seen other people say, no way, the judges in our jurisdiction would not do that. That's not a thing, that doesn't exist, and that's not a possibility. So just for people watching, you can, it doesn't hurt to ask. The judge might tell you, no, that's not really a thing. We don't transfer cases to USCIS. We only dismiss, we can terminate it and then you refile. But I have just anecdotally see some people say that judges have gone ahead and put that in writing for them. But regardless, don't be deterred by the 1 year filing deadline. If you have a client who's in immigration court and your case is going to be dismissed from immigration court because of the possibility to seek TPS, go ahead and refile for asylum affirmatively before USCIS, even if that 1 year filing deadline has passed. And I think, that's what Cassandra is saying here. You she explained the process for how to do it. But don't let that get in the way or block you from moving forward with this case, because as long as your client did comply with the 1-year filing deadline in immigration court, you can just attach that that proof and follow the procedures that Cassandra outlined, and you should be able to still move forward affirmatively for your client.
And
And then one other
I
question.
just wanted to,
Sorry, go ahead.
sorry, I just wanted to add, if it's not a strong case, it doesn't mean you have to do it. I'm just saying, like, if it's a strong case, you believe and you want to go forward, yes. If it's not a strong case, that could have been your out to be out of removal proceedings, your client to be out of removal proceedings and not put them back in by submitting a weak case, because it's going to eventually get back to the court if it gets if it doesn't get approved.
That's an excellent point. So yeah, just that's another strategic consideration for everyone to keep in mind, and why TPS is such a good option for people who don't have strong asylum cases. If someone is submitting an affirmative asylum application after they've been removed from court, what are the procedures for where they need to send it? Is there any special instructions there?
I submitted the same way I would submit a brand new application. Somebody who comes in and tells me they want to file for asylum, that's the same procedure. The only difference is it will be documenting showing that it was filed with the court within the 1 year. That's the only difference. Think about it, it's just somebody who wants to file for asylum, you follow the same procedure, but that box for the 1 year, you're just documenting it.
Great. Okay. And keep an eye out for online. You can look on the USCIS website online for where to mail the applications. If it's a case that was in removal proceedings and has been dismissed, it needs to go through the asylum vetting center, which is a different address if you're mailing it. So that's just something to keep in mind as well. Now let's move on to a really important topic, firm resettlement issues. This is something that I know is fairly common with a lot of Haitian clients who are seeking asylum and TPS. But Cassandra, could you explain for us what is firm resettlement?
Basically, firm resettlement is, I could read the definition, an applicant is considered to be firmly resettled if prior to arriving in the United States, applicant entered the country with, or while in that country received an offer of permanent resident status, citizenship, or some sort of type of permanent resettlement. Basically, it's saying that this is from the asylum law. So if another country offer you some sort of refuge and a third country, you shouldn't be requesting asylum in the United States. So they're using basically that same model for TPS purposes. Did another country offer you some sort of refuge, some sort of permanent status where you could enjoy the same rights and privileges as a citizen of said country?
Okay, and who bears the burden of proof to show firm resettlement?
So the government attorney, DHS, bears the burden, not you as an applicant. The government attorney needs to bears that burden of proof. Once they establish it, you have the opportunity to rebut said burden of proof, said assessment. So please be mindful is you're not the one who has to show that the person is firmly resettled and explain why they didn't firmly resettle. You submit your application, you make your assessment, and it's the government that has to raise the firm resettlement issue, not you.
Okay. And if there is a firm resettlement issue, should people still move forward and apply for TPS? What are you seeing in terms of whether this is an actual bar to receiving the benefits in practice?
Well, if the person's already in removal proceedings, it doesn't hurt. At the end of the day, the worst has already happened. They are in removal proceedings. Why not try it and do it? And also, if you're going to pursue the asylum, the firm resettlement issue, it's the asylum law that you're going to argue before the judge. Why not argue it for TPS as well? Stephanie, can we go to the next slide? Is it the one with the chart?
Yes, I think. Yes.
All right. So basically, the person's already in removal proceeding, as I mentioned. It doesn't hurt. The worst that will happen is the person gets denied. And that particular case, if you feel like there's a firm resettlement issue, do not pay the full $545 for TPS. Just do the TPS portion, which is $135. See what USCIS says. Then after that, if it gets granted, you'll decide whether you want to do the EAD under asylum if they're eligible, or do it under TPS. If the person's already eligible to get an EAD under asylum, I would advise you to just continue on the asylum one instead of a TPS, because the TPS has a definite deadline, which is the date of the last day for the registration period. As opposed to asylum, it gives you 2 years from the date of approval. So that's a little practice tip right then and there. Now, how would you make an assessment of firm resettlement? So the first thing you ask yourself, is the applicant a national of Haiti or a person who without nationality has last resided in Haiti? If it's a no, the person is not a national or did not have a nationality and last habitually reside in Haiti, the person is not eligible for a TPS because the person has not met the basic requirements. But if it's a yes, your second question is, has the applicant lived in a third country or a country with other nationality? If that's a no, you proceed with the other requirements for TPS. But if it's a yes, now, because again, we're making a firm resettlement analysis at this point, did the applicant obtain or was the applicant offered a permanent status? Now, the fact that the person did not obtain it doesn't mean that there's not a firm resettlement issue. Was the person offered and the person could say, well, I don't want it. Just because you were offered, there may be a firm resettlement issue. So just because the person didn't take it doesn't mean that there's no firm resettlement. And please be mindful, for instance, Brazil, there was a time frame during the Olympics and the World Cup. There are a lot of Haitians that migrated to Brazil, and after a year, I heard there was some sort of list that their name and their passport information came out. So that means they were eligible to get permanent residence. So they were offered that permanent residence. The question is, did they take it? Some people were unaware, so on and so forth. So just because you didn't take it, that doesn't mean there's no firm resettlement issue. Now, if the person obtained or was offered firm resettlement, if that's a yes, okay, you're going to do a firm resettlement analysis. If that's a no, right, the person was not offered or the person did not obtain any permanent status, okay. Now, some practitioners love to be proactive, right? Okay, I know there's no, okay, the person did not offer any, there was no status offered to them. The question is, should you submit an explanation, right? Or wait for an RFE? Should you offer an explanation? This person lived in this country but never got status. They lived at there, didn't have a status. Should you offer an explanation? That is really up to you. I've seen practitioners offer a lot of information about the situation. Others just say, well, I live in this country, no status, right? No further information. But let's just say the person they offered some sort of permanent status or did get some sort of permanent status. Now you're gonna do a firm resettlement analysis. Okay, have the firm resettlement based on what you just witnessed. Let's just say the person has something that says permanent. Okay, yes. Can it be overcome? Can you overcome that firm resettlement issue? And there's different ways you could overcome it. Overcoming it means that, again, the premise is, just because you were offered some sort of permanent status, did you enjoy the same rights and privileges as the citizen of said country? So if you did not enjoy the same rights and privileges, although there's an argument that you firmly settled, but you could overcome it. Let me give you an example. I had a case where Haitian national lived in Brazil, did get a residence in Brazil. But during the asylum proceedings, the government attorney raised the firm resettlement issue. And again, just remind you, firm resettlement is from asylum law that they're applying for TPS. So it's the same standard. So at that particular point, when they raised a firm resettlement issue, I argued that she did not firm resettle because she did not enjoy the same right and privileges as other Brazilian. And the example I gave, she was pregnant, she worked in a factory, and she noticed that Brazilians that were pregnant She was working at a chicken factory where they would pack the chicken. It was really cold. When the Brazilians were pregnant, they were removed from the assembly line and were offered in another section. They would be seated. She would never offer that. And second, according to Brazilian law, I believe 3 months before you give birth, you could go on maternity leave. And they did not offer that for her. She remained on the assembly line up until the day she gave birth. And I provided the labor law showing that, and her testimony. The judge believed it. So the judge found that there was no firm resettlement because she did not enjoy the same rights and privileges as other Brazilians. So you could make that analysis. So if, for instance, you believe that there was no firm resettlement, but there's an issue whether they were offered some sort of permanent status or they did obtain some sort of permanent status, again, should you submit an explanation? Again, as a practitioner, it is up to you. But the only thing I need to remind you, it's not your burden. It's DHS's burden. Your obligation is to file the application. DHS's burden is to show that there's firm resettlement. Let's take hypothetically, let's just say, I want to be proactive. I want to tell the government everything and be proactive. You're submitting the permanent residency card from Brazil. You just literally provide it to the government because you wanted to be proactive and put it on your TPS application. Imagine the asylum claim in front of a judge. They didn't have the card. They didn't have the card with them. But guess what? You submitted on the TPS because you were being proactive, and the government attorney said, Judge, guess what? When they file their asylum application, here's a copy of the card. There's a firm resettlement issue. So don't do the government's work for them. You are going to be honest and say, yes, the person did receive residence in Brazil. It's up to USCIS to bring the firm resettlement claim. It's up for the government attorney to bring it in court. So don't give them the tools to say, Judge, we just met the firm resettlement bar because guess what? We have the card. No. Let them raise it, right? And if the judge says there's a card, you provide the card, but you already have your analysis to overcome that. And that's where a conversation with your client is needed, right? When I have a firm resettlement issues, I don't sit there and say, oh, there's a firm resettlement. No, I sit there and have a conversation. I say, okay, how was your life? Why did you leave the country? Tell me why. Where were you? How they were treating other nationals of that country. And I sit there and there's so many discrimination against certain nationalities because of race, their nationality, that you have to be aware of, but you won't be aware of because guess what? I try to get those documents, country conditions, they're not reporting them, right? And when they're reporting them, they're very few. So at this point, it's your client's testimony, and you have to understand where the client's coming from in order to help them express how they didn't enjoy the same rights and privileges. So that's why I do not. When I'm doing asylum or TPS, I do not bring the proof. I have it there. If asked, I will disclose it. But it's the government attorney to bring it up. So I don't do the government's job for them.
That's a very helpful reminder about the important conversation to have with your client, and that it's important to, of course, be truthful in the application, but not do the government's job. Don't meet the burden. Don't shift the burden to yourself unnecessarily, and the implications that it could have for future asylum applications based on your TPS application as well. So thank you. That's really helpful information. Moving to the next slide, which I think should load in just a second. I don't. There we go. An issue that kind of goes hand in hand sometimes with firm resettlement, or that could come up, is dual nationality. What do we do, or what are some strategies or things to consider with dual nationality, and can people who have dual nationality still apply for TPS?
Absolutely. People with dual nationality can apply for TPS. It doesn't categorically make you ineligible. It could just raise a firm resettlement issue. That's all it could do. And at that point, just be mindful, since we're talking about Haitians and removal proceedings, please be mindful, Haiti is a country that is a jus sanguinis state. That means Haitian nationality is conferred by blood, not by soil or soil. So therefore, I could be an American citizen living in Haiti, gave birth to a child, that child's not Haitian. But I could be a Haitian national living in Brazil, gave birth, this child is a Haitian national. So because national is transferred by blood. So therefore, if you have an applicant, a child who was born of at least one Haitian parent, you could file for TPS for that child. Now, the biggest issue that we're seeing is proving the nationality, right? Because we have instructing people to go to the Haitian embassy or the consulate to get some sort of documentation proving that they're Haitian nationals. However, it's very difficult to get. So what we do in those cases, we provide their birth certificate, a section of the Constitution, of the Haitian Constitution, recognizing dual nationality, recognizing that they're Haitian national, and proof that their parents or one parent or parents are Haitian nationals. So probably the parents' passport could be one of them. But we provide all that, and we provide in the cover letter saying this person is a Haitian national.
Got it. So you need to maybe do a little extra explanation for children who were born in third countries. But if we have a child who was born in Chile to Haitian national parents, then that child is Haitian and can still seek TPS even if they weren't born in Haiti.
Correct.
Moving on now to our next topic, which is some special considerations for the TPS extension and redesignation periods in particular. Is there anything specific that practitioners need to keep in mind when working with TPS applicants during a redesignation or re-registration period?
Yes, the most important thing, you have to know your dates. You have to know your re-registration date, and if there's a redesignation, the initial registration date for the redesignation. That could be a bit confusing, especially with Haiti, who had 4 TPS. For instance, the 2021s, people who applied in 2021 and got approved, they have until March 27 to reapply to maintain their TPS status. For the ones who are applying for the first time, for 2022, they have from January 26, 2023 until August 3rd, 2024 to apply. Now, there's a caveat for the 2011, the second TPS one. Just be mindful, the second TPS, when under the past administration, they tried to terminate TPS for certain countries, Haiti was included, litigation ensued, and the Ramos case is in place. Because there's pending litigation, termination for a TPS for 2011 cannot happen up until there's a decision on that court hearing. So therefore, they have instructed, because they cannot terminate TPS, it's automatically extended for the 2011 TPS applicants. So if you have a 2011 TPS applicant who has not filed for TPS in 2021 or will not file for 2022, their expiration for their current TPS is June 30th, 2024. If you had one who applied in 2011 during the 2021, so they're in the second TPS, they apply for 2021, which is the third TPS, they're now considered under the 2021 category. So because, although they had it before, because they applied for 2021, now they fall under the re-registration period. So that's where it gets a bit confusing, especially for the second TPS, the 2011 one. And just be mindful, again, I mentioned it, if you have somebody who has TPS and who's eligible to get EAD under asylum, it's best to do it under asylum because it's 2 years from the date of approval, as opposed to TPS, which is the 18 months given.
That's a great consideration to keep in mind. And I think we have a few more slides on these special considerations, and I see questions coming into the Q&A box, but just a reminder for people, you can go ahead and ask questions now, and we just have a few more slides, and then we'll turn to the Q&A. So Cassandra, I think there's a few other special considerations here.
Yes, if somebody is reapplying, re-registering, please make sure you check the re-registration box. If there's, for instance, the 2011 ones who are applying for the 2021 or 2022 redesignation, because it's a redesignation, it will be considered as an initial. So even though they had TPS in 2010 or 2011, that will be initial, so they should check initial.
Okay. And then just a few more key pointers that you've highlighted for us here.
Yes, and the other thing is be mindful. Some applicants will not have the funds, may not have the funds. Just protect their TPS. first, then you could try to do a fee waiver under fee waiver for the work permit. Also, a lot of Haitians who have entered work parole and they are considered Cuban Haitian entrant, they should be eligible for mean testing benefits, which they could do a fee waiver under for the TPS. Many TPS holders will inquire about travel authorization. Again, as a TPS holder, you are eligible to request for travel authorization, and you are eligible for that. But please be mindful if you have an open court case, if you are if you're in removal proceedings, if you have a pending asylum, or if you had some sort of status in a third country to prove. Do not travel in those countries because remember, TPS is temporary. Asylum is a permanent status. So do not compromise your potential permanent status by traveling in home country because it's going to most likely weaken your case if they see you say you're afraid of going back to your home country, but once you have the travel document, the first thing you want to your home country. So please be mindful.
Great, and that was one of the questions that had come in our Q&A box. So that was a perfect answer. There was, what to do if someone wants to travel back to Haiti during TPS. So we got ahead of one of our questions, but I'm going to jump now to some of the Q&As, the questions that have come in. So let me just take a look here at some of the. So one question that came in is, if you have an employment authorization document under another category, can you apply for a TPS EAD as well?
Yes, you can. The question is, why would you want to do that, right? Because there might be fees involved. So just be mindful of that. Also, just because you're switching categories, because there's an extension of, you could still work if, depending on the category that you're working, be mindful of that. If you have a client who has a C11 category or whatever category, and you're switching the category, that receipt, because it's not the same category, does not really allow them to maintain their employment status, employment authorization, their job. Because right now, given the delay in immigration, you have to remain in the same category to have that extension, which is I think 540 days, right, Stephanie? That you could
Mm-hmm.
work in that time frame.
Exactly.
So please be mindful. Yeah.
Another question that came in is just about timing of piecing the different pieces together. So client had TPS since 2011, was part of the 2011 TPS. We refiled for 2021 designation, but that application is still pending. In that case, does the client need to re-register before March 27th, or what should happen if that 2021 application is still pending?
So if the application is pending as of January 26, 2023, it's considered pending. They don't have to refile. Once it's approved, they'll have the August 3rd, 2024 expiration date.
Great. Okay. And how do you handle cases where someone's not exactly sure what their status was in the third country? I know you did a great analysis of what to do for firm resettlement, but if someone's really not sure if they had a temporary status or a permanent status, they just don't quite know.
Well, at the end of the day, it's a good faith by your client. If the person says, I'm not sure, I don't think so, you check, say, okay, I unknown or no status, whatever the person disclosed to you. Now, if it comes to light at some point, you're gonna have to sit with your client saying, well, why didn't you tell me this? And they could have a good explanation of why. Some of them really don't know what status they had. Some of them think because their status expired, it was a temporary status. Some of them lost their paperwork. That's a conversation you have to have with the person. And once it's brought up by DHS, you just have to have a conversation with the person, do further research based on what DHS alleges, and you're gonna overcome it that way. So if they say that there was a firm resettlement, although you said you didn't have any permanent status, you said it was temporary, it's permanent. So this is when you're gonna have the conversation with this person, saying, okay, this is what DHS alleges. What happened what happened in that country? Why did you leave? Have all that analysis. So when you're applying to the RFE, you're overcoming the possibility of firm resettlement at that point.
Got it. Okay, great.
Stephanie, I
Go
think
ahead.
somebody asked for Haitian with, I say for Haitian with prior theft felony, is there a waiver if the felony happened in 2001? I'm glad, that's a good question. It doesn't matter when the felony happened, it knocks you out automatically. If you have one felony or two misdemeanor, it doesn't matter if it happened in 1963, it still knocks you out. The only way you could do it is if probably you try some sort of post conviction relief where probably you could get the felony reduced to a misdemeanor. If that's the only misdemeanor, great. Or you get it dismissed. I mean, nolo pros or not guilty or so on and so forth. So there's no adjudication. That's the only way. Doesn't matter the year it happened. If it's a felony, you're out.
Good to know. And unfortunate, but it's good to keep that in mind.
Mhm.
Let's see. What about fee waivers? Can you file a I-912 fee waiver for TPS?
Yes, you can. The caveat, I believe, you can't do it if you're filing it online. So if you're doing a fee waiver, it has to be done on paper.
Um, let's see. Can I move to terminate a case if the next hearing date is after the current TPS expiration date?
It depends. If the person, it depends on the judge. Is there something else you wanted to add, Stephanie?
Nope, nope, that was
Okay.
it.
Oh, it depends on the judge. It depends on whether they granted it, right? It depends if it's still pending. It depends if there's a re-registration, an extension. So there's so many factors. So my thing is, if you are in a jurisdiction just by filing the TPS, they would consider dismissing the case, and that's what you want. Just do it now. Don't wait at the end of the day because with different administration, things happen. Don't wait until it gets approved. If they're considering it now and that's something that you wanted for your client, do it. If it's something that's a challenge, that's something that you've been trying to do, I would do it at every stage. Do it when you filed it. No, counsel, they're not eligible. It doesn't mean that they're eligible for TPS because it's still pending. The moment it gets granted, try it again and see what happens. So I would just try it at different stages depending on the case. But if it's something you want, fight it for it the moment that it's eligible. The person's could do it, which is file a motion the moment it's received. We get the receipt. You never know.
Mhm. Let's see, one other question that came up is about the TPS application is not available in Creole. Are a lot of your clients facing language barriers, and how are you addressing this in practice?
Well, the good thing I'm Haitian, so it's not a problem for me. But the thing is, at this particular point in time, have it in Creole. We could try to provide resources where we have it translated in Creole for efficiency purposes, but at the end of the day, the applicant still has to complete it in English, right? So probably we have the Creole version for the applicant to understand the questions, but it's the English version that has to be filed with USCIS. And we're working on having a Creole version, so I could provide it to the ABA once it's available.
Great, and then we can circulate that widely. Um, and we've got some other great questions here that I think a lot of them are addressed in our material. So I'm just going to do one more before we close, which is just in practice, are you seeing DHS come up with evidence of firm resettlement for Haitians in third countries? The question's about Chile specifically, but are you seeing a lot of that in practice, or is it something that DHS is not really making a big issue out of?
I'm not seeing it in the TPS context. So far, and we've been 2 years in. I haven't seen it in the TPS context, but I've seen it in the asylum context when they're in court. Especially for Brazil, that list was provided by DHS, and I have a copy. And whenever I have a client, I go through the list to see if their names was on the list to be offered some sort of permanent status.
Okay. Great, and we are at time. Thank you so much for everyone for your questions in the Q&A. That's all the time we have, and so before we leave, I just wanted to ask all attendees who want CLE credit to stay connected for instructions on how to get your CLE certificate, and please wait for the evaluation that will pop up on your screen. To our faculty for this program, Cassandra, thank you so much for sharing your expertise with us today. This was such an informative session. And on behalf of the ABA, I'm Stephanie Baez, thanking you all for joining us. I'm now going to turn it over to our operator to provide some additional information.
Thank you. On behalf of the Bar Association and the ABA Commission on Immigration, thank you for participating in this program. To learn more about the sponsors, visit the ABA website at .org. Thank you. Again, click on the evaluation link. We value your feedback.